Good afternoon, and thank you for joining us. I'm Robert Baylor, Director of Communications at NUCA. Welcome to our fourth NUCA Construction Law webinar. First, before we begin, some webinar housekeeping for attendees. Today's webinar will be recorded. It'll be available on NUCA's YouTube channel and on our Construction Law webinar webpage, both of which can be accessed via nuca.com. All participants are muted upon entry. Phone participants can use *6 to mute and unmute themselves. Questions will be asked at the end of the presentation. To ask a question, you can submit a written question at any time using the chat feature, and I'll read them at the conclusion of our discussion. Now let's get started. Today's construction law webinar will discuss liquidated damages. There are some sure things in life: death, taxes, and the assessment of liquidated damages. But with regard to liquidated damages, there are tried and true strategies that have helped contractors limit the damage to their bottom line. Our presenter will share those strategies with you, our loyal NUCA members. Tom Olson and Sean Farrell are well known to NUCA members as voices of authority on construction law. Tom is chairman of the NUCA Legal Committee and practices law in Minnesota as a founding partner of Olson Construction Law PC. Sean cannot be with us today because of extenuating circumstances in his home city of Philadelphia, so Tom will lead the discussion today. Thank you all for joining us today on this NUCA Construction Law webinar. Tom, I turn the webinar over to you.
Right on. You got me ready to go here?
I know Zach is changing it over right now.
Let me know when I'm ready to go.
You should be good to go.
Okay, thank you. Well, good afternoon. I really appreciate the opportunity to talk about, obviously, a topic that's hugely important. I want to start, before we do that, a couple of housekeeping things on my end. First of all, I want to wish everybody a Merry Christmas. In that regard, I really encourage each of you to embrace what I think is the greatest gift of Christmas, which is health and the opportunity to enjoy that another day. Sean's not with me today because as his wife is suffering some medical conditions that are uncertain, and therefore I hope you'll keep Sean and his wife in his prayers. In addition, I want to share my best friend of 43 years who was just ready to retire this spring. I just learned on November 2nd that he has stage 4 pancreatic cancer. So, again, I really encourage everybody to really appreciate, what we got. Again, health and another day to enjoy it. All right, turning to the topic at issue. So, again, my presentation today is informed of 38 years representing contractors around the country. And my strategies today is really about how do you minimize the assessment or otherwise prevent it, the assessment of LDs, and accomplish that on a cooperative basis as opposed to being cavemen in clubs battling in a courtroom. Okay. The art form is to get somebody to say yes, or in this case, no, to the assessment of LDs, and to get that done cooperatively on the job site. So listen through the lens of that. Okay. And the strategies to do that are threefold. One, finish your project, your work on a timely basis. Two, if you fail to do that, make sure you don't delay project completion. And if you fail to do that, make sure you don't cause the project owner an unanticipated loss of use. All right. Mindful of those three strategies, let's start with the first one, which is, how do I finish my work on a timely basis? Well, when you bid the job, be it as a GC or as a sub, certainly you anticipate that you can do that, and you're submitting a price on the basis that you can. Now, obviously, that doesn't happen so often, and based upon my experience, one of the big reasons is that a schedule is not properly used in order to reflect your bid assumptions from a duration standpoint during the build phase. And this applies equally to a GC as well as a sub. Let me start from the sub standpoint. Now, typically when you are provided a subcontract, and I know that because I prepare subcontracts for GCs as well as representing subs, the subcontract typically will afford the GC pretty much unlimited discretion over the scheduling of these subcontractors' work. Now, keep in mind that's a proposed schedule. Proposed in the sense that when you get that standard form subcontract from a GC, you're not required to sign it. You're required to negotiate because all the terms that are included in that proposed subcontract are new. Therefore, it's just like a counteroffer that you can accept or otherwise not negotiate. So what I encourage you to do when you're a sub, when you get a standard for subcontract, to ensure that the subcontract reflects language that as it relates to scheduling affords that the schedule that you're going to be held to as a sub shall be one that's mutually agreeable. I get, when I represent subs on a regular basis, I get such language agreed upon because it's fair. So you want to make sure that as a sub, when you sign that subcontract, you're afforded the opportunity to be involved in preparation of the schedule that's going to accurately reflect the job as you bid it. That's a huge step. And if you get nothing more out of what I say, get that, because too often subs don't do that. And therefore they lose the ability to have a schedule afford them the amount of time to complete the job on a timely basis. Okay. So the sub, you now have the right to participate in the schedule that's going to be mutually agreeable. And now the key next step is making sure that that schedule is prepared prior to the start of the job, prior to the pre-con, and that you have an opportunity to review it in order that the proposed durations match the durations that you contemplate that are going to be required to complete the estimated quantities of work under the conditions that are required. And certainly, if you anticipate one mob, you want to make sure that the job schedule reflects that the sequencing of the work doesn't require you to stop partway through and stop later. So again, you as a sub want to make sure that that schedule is going to reflect your bid assumptions from a production standpoint. And then prior to the pre-con, you work with the GC to prepare an acceptable schedule. You want to sign off on that. And what's interesting about that is I was involved on helping a GC in a large DOT project out west. There was a pay item for preparation of a CPM schedule. I've got background with CPM scheduling. And I worked with the general and recommended that the general include the subs in preparation of that. And what was unexpected that the GC learned was by involving the subs in the preparation of the as-planned schedule, the subs actually wanted shorter durations than what the GC proposed. So, following the approach to co-opt the preparation of that as-planned schedule with the assistance of subs actually resulted in a schedule that had a shorter overall duration and therefore provided more assurance against the assessment of liquidated damages. So we've got an as-planned schedule prepared that's been jointly prepared and acceptable by both the subs and the GC. Now, in order to back check whether you've got an acceptable as-planned schedule, one way to back check that, and probably the easiest way to do it is this. For any activity that's going to be included in that as-planned schedule, you want to take the estimated quantities for that particular item of work. You want to divide that by the proposed duration. That should equal your planned daily production plus or minus. If it doesn't, you need to revisit it and revise it in order to reflect the as-planned daily production plus or minus that's in the bid. And that applies both for the bid for the sub as well as the bid for the GC. Again, an accurate schedule for each line item is going to ensure that the estimated quantity when divided by the proposed duration is going to equal plus or minus the planned daily production rate. If you've got that, you've got a good proposed as-planned schedule. Now you've got somebody that's going to work for the GC as well as the subs. The next step is to have that prepared, agreed upon between the construction team prior to the pre-con. Then what you want to ensure is that that pre-construction meeting, the GC is going to present that to the engineer. Again, I think about the pre-con as a honeymoon. Everybody loves each other. There are no issues affecting time, dollars, or constructability. That's the best time to get agreement on the proposed schedule. So what you do as a GC and as a sub, you want to make sure this is accomplished by the GC, is that the pre-con have the general contractor submit that proposed schedule, as planned schedule, to the engineer in order that can be discussed at the pre-con. to invite the engineer, that if the engineer has any questions, comments, disagreements, to have those voice communicated. What you want then is to ensure that either at the conclusion of the pre-con or shortly thereafter, you want written agreement from the engineer that the as-planned schedule is not objectionable. Which, in other words, the engineer might not sign off and say, I think this is a reasonable schedule. But at a minimum, you want the engineer to say in writing that there's no problems that it sees with regard to the proposed logic or durations. That's critical because then you have the buy-in, the sign-off of the engineer that the planned durations are reasonable. Critical. Because then when you get into a change situation later, you're not having to argue whether those planned durations are reasonable or not. You've already got that. So you're halfway through what you need to do in order to get a time extension when the time required to get the job done changes. Okay, so you've got the proposed schedule signed off on by the construction team as well as the design team. All right. Now, and obviously then before the work starts, you want to make sure from the GC standpoint as well as the sub standpoint that you're getting a copy of that as planned schedule. You want to get that not only for your work as a sub, but also for the entire project. I'm certainly a proponent two things. One, that you, as a GC, you should be using CPM scheduling. Certainly more and more contracts, and it goes, I think it's standard on DOT contracts that they require CPM scheduling. The benefit of that schedule, that software, it allows you to reflect what's the critical path. You do that by way of the red ink. The other way that you identify the critical path is you include the column that lists the float. And for all the activities that have zero float by definition, that equals the project critical path. In other words, if there's zero float, that means the earliest date that activity can start is the latest date that can start. And therefore, all of those activities that have that zero float, that comprises the critical path. A reason you want to have that critical path identified is that what happens sometimes is that the critical path can be delayed for any reason. The owner doesn't have the required easement. There's delays caused by a railroad, by utilities, different site conditions, design bus, whatever it is. And in response to that, typically what will happen is rather than the sub or the general that's doing the work demobbing from the job site, they're going to look to other work, albeit non-critical work. Well, what's important to understand is you can work a full 10 hours on non-critical work, but for every day that you're not doing critical work, although you might be spending 10 hours working on non-critical work, there's a day-for-day delay to project completion, right? Because the critical path of work is controlling it, not non-critical work. And the way to effectively communicate that to the engineer, which my experience is often problematic because the engineer will say, how can you be delayed if you spent 10 hours working on the job? The answer is because I was working on 10 hours of non-critical work. And to ensure there's no dispute that I'm working on non-critical versus critical work, that's why you want the schedule, the as-planned schedule, to reflect what's critical work by way of the red ink, as well as listing of the activities that have zero float, because zero float activities define the critical path. Okay? All right. Once work starts, you need to regularly, as a GC, regularly update that schedule to reflect the actual job progress. You know, I've had conversations with GCs before when they push back on use of the schedule on highway heavy. It's been more use in vertical construction for years in highway heavy, but I'll get pushback from a GC saying, the problem with using a schedule is the day that I step foot on the job changes. And my answer is exactly. That's why you use a schedule to reflect the job as built, in order that when it necessarily changes, you're in a position to compare the change, measure it, as well as identify what's causing it by comparing the as-planned schedule with the schedule update. So it's important that the general regularly update the schedule to reflect actual job progress. How often a GC should update that reflector schedule is going to turn on the size of the project as well as the length of the project. It should be quote unquote regularly updated. What that constitutes is going to depend. If I got a year project, certainly in my opinion, that's going to reflect updating it no less than once a month. On DOT projects, for example, it's a contractual requirement, if not to update it monthly. At least it's incumbent upon the contractor as a matter of contract under literally any DOT specs to update it whenever the planned durations, sequencing of the work change. Otherwise, the planned completion date is being pushed back. And it's a contractual requirement to do that. And if a GC is not doing that by most DOT specs, that's going to undermine their ability to get paid, because the duty to update the schedule on a timely basis under DOT specs is a condition precedent to the right of a GC to require payment. So that's incumbent not only for the GC to do that, but obviously for a sub, to the extent that the sub's right to get paid, it's going to be dependent upon the GC getting paid. Okay. So the schedule is being updated on a regular basis to reflect actual job progress. Number one, that needs to be done. Number two, when that schedule is updated, not only does the general need to give that a copy to the engineer, but often also it's equally important to provide that to the subs as well as suppliers to understand what is the status of the work right now with regard to them. Is it that they have to be on the job site potentially earlier, later than planned? If the work has been started, but it's been interrupted, delayed, disrupted, the sub and supplier needs to understand that in order that they can respond to it appropriately. Too often a GC as well as a sub misses the importance of a tool that a schedule can provide to coordinate the timely completion of a work. So it's in the interest of both the GC and subs and suppliers that a schedule is updated and used during the course of the project to help coordinate the timely performance of work in order to protect against the assessment of LDs. All right. So speaking of the work being disrupted, delayed, when a work is delayed, disrupted, be it a compensable delay or not, certainly if it's delayed or disrupted, that then provides potentially the basis for time extension. And whether it provides a basis for time extension, it's going to be a question answered by the contract. So in order to understand your rights for time extension, it's incumbent that for any job that you're doing, you understand what the contract says with regard to the grounds, the basis for time extension. For example, some contracts don't allow for an extension for adverse weather, others do. I will tell you with regard to when you do have a right to a time extension for adverse weather, often there's very specific contractual requirements that you've got to meet, and they can be very detailed. So you need to make sure for delays caused by weather or whatever it is that you identify what the contract requires. Do I have a right substantively to a time extension? And if I do, procedurally, what am I required to do? When am I required to give notice? Typically, you're going to be required to give notice when that time extension, that disruption delay arises. Often you're going to be then required to track the impact. And then when that delay is completed, to submit a request for time extension. What I find too often is when contractors are missing or failing to meet the procedure requirements, they might otherwise be talking about if they are verbally, not in writing. And again, I can't emphasize enough, on public construction contracts, literally any changes for time, dollars, and constructability require written notice. And that holds true for literally any public contract other than federal contracts. Federal contracts, verbal notice can be sufficient, provided that the project owner is not prejudiced by that. But don't think of that. Think about any project that you're doing, you want to give written notice, and as to what written notice, as well as any other procedure requirements there are, review the contract, identify what they are, make sure that you're doing it. To the extent that you're using standard form specifications on a regular basis, you should be putting into your software what those requirements are. And then when those delays arise, you don't have to create the notice or any other procedural actions that you need to take or substantive ones. You've already got that in your software system, and then you can just plug in the project name and the specifics for that in order to meet the procedure requirements. Let me tell you, and I can't emphasize this enough, when we're retained, more often than not, we're retained after the fact when the contractor, be it a sub or a GC, has failed to meet the procedure requirements, and we're getting paid trying to figure out a way around that. I can assure you a much better approach is to contact a lawyer, be it me or somebody else, when the issue first arises, in order that you can get assistance to determine, one, is this a delay for which I'm entitled to time? And in addition, is it a delay that I'm entitled to additional compensation? You want to know that, be able to identify the applicable contract provisions, and then knowing that at the outset, be educated in order to know how to meet those contract provisions. Let me tell you, it's a lot easier to get somebody to say yes initially rather than trying to change no later. The way we get yes is to do what the contract says. And keep in mind, the reason those procedural requirements, in my opinion, are included is by way of giving the engineer timely notice. The engineer is in a position to understand that it's a delay, understand that it might delay project completion, understand that it also might cost the owner additional money. And by having that timely notice, it gives the engineer an opportunity to evaluate it, to see if they agree, see whether or not there are alternative means that may be available to get around it. I know, for example, I remember I had years ago a big two-phase highway project, included paving as well as utility. And the first phase was being delayed by untimely utility relocation. We raised the issue at the outset with the owner through the engineer, and in response, the engineer made the second phase available because the second phase could be started insofar as it was not being delayed or would not be delayed by the utility. That would not have occurred but for giving immediate written notice. So again, make sure you're doing what the contract says. Of course, you can't do what the contract says unless you know what the contract says. Okay. So when you've got that delay, you're giving a written notice. For the general contractor, on behalf of both the GC as well as the sub, the easiest way to measure the impact of delays, both in time in order to avoid the assessment of LDs, and dollars when you can to get paid for, is what you do is you update the schedule at the start of the delay. And the update reflects the status of the job if it wasn't being delayed. Then once the delay ends, the GC should update the schedule again, because then that allows the GC on behalf of itself, as well as the sub, to capture the impact of the delay in both time and monies, because when that schedule's updated, it will reflect the delay to project completion. And then that would be, or if you're looking for an extension to project completion, you've got the ability to do that. If it's the sub, it's a delay to their work, but not necessarily a delay to project completion, it allows the sub to have the delay for which it's entitled to a time extension measured. So that's an easy way to do that. Easy way to get yes initially for getting that time extension agreed upon then. Keeping in mind that if you're not getting a time extension agreed upon during the project, what you face, and I'm not telling something that you don't know, is you get at the end of the job, the completion date hasn't been extended, and as a consequence, the owner's assessed LDs. So now you're trying to negotiate from a position of weakness because you got LDs hanging over your head. A much more effective way to do it is get the time extension at the conclusion of the delay in order to avoid the assessment of LDs, in order to avoid having to try and negotiate that at the end of the project when you don't have the leverage. And what you're doing at the end is wearing out your knees trying to negotiate it because that's your position, trying to negotiate it then. Okay. Also important, a comparison of the planned completion, be it for the project completion or for the sub's work. Again, you compare the planned completion that's shown either by the as-planned schedule or the update if it's done at the start of the delay with the update that's done at the end of the day. And the difference is going to be the basis for time. It's also going to be the basis for dollars because whatever the amount of delay is in time, you use as a basis for dollars. You multiply the additional time times your daily resource cost. And if you got the right for extended GCs, general conditions, as well as potentially unabsorbed overhead, your baseline is by way of the extra time that the comparison of the plan versus the actual schedule, the updated schedule shows. Easy way to do it. I can tell you that I work with contractors around the country, and some of my best work is a limited amount of work that I assist them behind the scenes to get that done properly, and as a consequence, get the engineer to say yes initially rather than trying to change a no later. Because if you're waiting until the end of the job, the problem, of course, is subsequent to that delay, there can be all sorts of issues that arise that can delay the job. And now what would otherwise have been a very simple, straightforward matter to get a time extension at the time to avoid the assessment of LDs later is now complicated and caught up in all the other delays that have occurred subsequent to that, and all the other issues that might have arisen. Now you're in a position of having to try and separate all those subsequent delays and issues. And now you're having to hire someone like myself. The cost of it is so much greater, and the ROI typically can suck. And I don't want to be involved in something like that. I'd much rather be involved on a limited basis, getting it done right initially when it's simple, straightforward, and we've got a path to get yes initially. Okay. The other thing I wanted to say about is a comparison of the plan versus the actual in connection with the delay shows a difference to delay. It doesn't show why. In order to show why, it's incumbent upon the sub, it's incumbent upon the GC to maintain daily documentation to explain the why. Why is my work being delayed? So therefore, it's critical that your field people understand that part of your job is not just getting production at the appropriate rate that as anticipated, but also when you're not, to be able to be tracking two things: why you're not, why you're being delayed, disrupted, as well as the extent to which you're being delayed and disrupted. And certainly an easy way to do that is to track your actual daily production. What am I getting for units? My plan, if my as-planned schedule accurately reflects, let's say I figured 200 lineal feet a day. Numbers don't mean anything. Let's just say I figured 200 lineal feet. And then I get into a situation where I got unmarked utilities. And I'm having to work around them, or otherwise I'm having to start. An easy way to measure both the cause of it as well as the amount of that impact is my daily report is reflecting, I'm being between station blank and blank. I'm being delayed, disrupted by utility that's unmarked, mismarked, it's late being relocated. And so that tells me why you're being delayed. And in terms of how much you're being delayed, my plan was 200 lineal feet. If I'm indicating for that day, I got 120 lineal feet only. That written in connection with the reason for that. Now I'm measuring on a daily basis the cause and the impact, such that when that delay is done, I collect that up and I've got the basis to get the engineer to say yes, as well as GC to say yes, to giving me an appropriate time extension at the conclusion of that delay in order to avoid the assessment of LDs later. Similarly, if to the extent that I have a right to additional compensation, following that same approach is going to situate you just as well to get the additional compensation you're due as well. Okay. And keeping in mind that you're being impacted when you're able to work, albeit at reduced production rates, as when you're being idled and you're not able to work at all. So you want to make sure you're measuring reduced productivity as well as no productivity when you're on those days when your idle's being ironed. I want to add one other point to that. And let's talk about it, for example, with utilities. One of the problems with utilities to cause delays, you often don't know, how long, if it's an issue of late utility relocation, how long that's going to take for it to be done. And one idea that I've utilized successfully is, if you wait around, if you're in a position where you can't do work and you're waiting around for the utility to relocate, one of the questions that you face is, well, how long is that going to be? Is it going to be a wait for 2 days, 5 days, or going to be a wait for 2 months? I know, for example, I had a job where utilities on a bridge, a demo job, were supposed to be done in spring, and the utility didn't relocate its line at the bottom of the bottom of the bridge until the fall. So, what you want to find out, be it as a sub or a GC, is when a delay occurs. If, for example, and this is the prime example, if it's late utility relocation, how long is it going to be? Is it going to be most cost effective for you to remain on site and charge for idle iron if you can't work, or otherwise, wait? Or if it's going to be a long delay, that's going to be better not only for the owner, but also for you to demob, get that iron idle on another job, and then potentially, if it's a compensable delay, the owner's having then only to pay for the cost for additional demob, remob. So that's an important approach to take. And before you answer that question, I encourage you to send an email to the engineer, if you're the sub, to the GC, and really ask the question, what should I do here? How long is the delay going to be? Am I going to have to sit idle, or should I demob to another job site? Because if you wait on site for a delay that can end up taking a long time, weeks, then the argument that I've seen raised by the owner, if it's a compensable delay, is, hey, you failed to mitigate your damages. You should have demobbed from the job site. If you would have done that, the costs associated with this would have been less. You want to avoid that situation by raising the question, asking somebody else, what do I do? One point I want to make about that that's very important, and it also relates to the issue of avoiding the assessment of LDs. It is often appropriate to mitigate damages to demob to another job site. And this is true whether you have a right to get paid or not. In other words, even if it's a non-compensable delay, it's in your interest, particularly so, to get that iron working on another job rather than sitting idle. What happens often, of course, is if you're going to demob that equipment to another job site, awaiting the time when the job that you're on is ready to be able to have you do your work, what will happen is that you're not going to want to leave that other job site, which is to say, remob back to the job site until the work on that other job site is completed. And what I've seen happen, in fact, I just got it right now in a job, is we demob to another job site to mitigate damages, and then the engineer sent notice that they were ready for the contractor to return to the job site. Well, the reality was the work on the other job site wasn't completed yet, and the contractor, rightfully communicated to the engineer that, hey, what, I am not available to return to the job site yet because I've got to finish the work on that job. I've seen engineers then try and assess LDs for the difference between when they said the job site was ready and when you got back there. That should not be the case. You properly mitigated your damages, be it dollars and or time, by going to the other job site. One way to protect against that, even on a better level, is when you opt, if you do, to demob to the other job site, indicate by way of your letter to the engineer, if you're the GC, a letter to if you're GC, the engineer, if you're the sub, the GC, indicate that I'm going to demob to another job site to mitigate the impact in time and potentially dollars. And I'm doing that mindful of the fact that I will not be able to return until my work on that job is completed. And that might mean returning later than you want me to, which is to say the job here may be ready for me to start earlier than I'm able to demote. Put in a letter that if you do not want me to do that, let me know in writing immediately. Otherwise, I will proceed on the basis that the appropriate step for me to do is demote to another job site, and that all of the delay attendant to that, including the time necessary to complete that other work before I come back, will be the appropriate basis for a time extension, if not dollars. That's a key step to protect yourself against the assessment of LDs. And again, I see it on a regular basis. The contractors, or rather the engineer, is ready for you to return before you're ready to return by way of having completed the work on the other job. You should not have to return until the work is done there. Key piece of advice, make sure you reflect that in your documentation to the engineer if you're the GC, to the GC if you're the sub. Okay.
We're at 35 minutes.
Okay. All right. I want to turn now, next step. If you finish your work late, you want to make sure that you don't delay project completion. As a utility contractor, your work's normally towards the beginning, and then certainly the below grade work's going to be completed before the above grade. You want to make sure that once your work is completed, if you've completed it late, you want to get regular scheduled updates from the GC afterwards to see whether or not work subsequent to yours may be the cause of delaying project completion. Alternatively, it may be that while you might have delayed the completion of the project when you were completed, that delay may be made up later, and obtaining scheduled updates afterwards will help you to know that while you might have completed the work late, you will not have ultimately delayed project completion, and therefore you should not have to pay LDs. Finally, if you do delay project completion, I've got 3 pieces of advice. Okay, the owner's right to assess LDs is tied to loss of use. That's standard law around the country. If the owner is not sustaining loss of use, notwithstanding the contract includes a liquidated damages clause, the owner does not have the right to assess LDs. Let me give you 3 examples of how I've successfully utilized that concept to protect contractors against the assessment of LDs in a cooperative manner. First example, the owner has no loss of use. So for example, I've got a job right now where the utility work is adding greater capacity for the water. All right. And as part of the contract, the contractor is required during the pendency of the work to provide temporary water. So during the pendency of the project adding additional water line capacity, there's no loss of use to the owner because the contractor is providing temporary water. Under those circumstances, notwithstanding there's LD clause, even if the contractor completes that project late, because there's no loss of use, there's no right for the owner to assess LDs. Again, I've used that very cooperatively in order to assist the contractor in not paying LDs. Secondly, the work starts late on the project, finishes late, but it completes with a planned duration. So the reality is, with all sorts of projects being done, it can be late starting on this project because of any assortment of reasons in other projects. And what happens often is, while you might be late starting this project by 10 days, it might happen, often does, is the project can get completed later, albeit 10 days later. So while the project starts late, finishes late, the time that there's a loss of use remains what was contractually contemplated. And therefore, as a consequence, there's no unanticipated loss of use to justify the assessment of LDs, even though the project started late, finished late. Again, I've used that successfully to cooperatively resolve the issues on the job site. Lastly, after a project is substantially completed, because the owner has use of the project, then an owner should not be assessing LDs thereafter for late final project completion, because since the owner has use of the project, the predicate for the assessment of LDs is no longer there. The owner has use of the project, and therefore every additional day that it takes to finally complete the project is not resulting in unanticipated loss of use. Again, under those circumstances, LDs should not be assessed for late final completion. So in conclusion, we've got the tools available to really protect against the assessment of LDs. Those tools should be part of your standard operating procedure with your company, within your company, and really encourage you to use those. I've spoken quickly. Certainly this is available online, and beyond that, if you have any questions, feel free to contact me. Again, my goal is to help you get your issues cooperatively resolved on a job site. Thank you. All of the advice that I've given to you has been battle tested on public construction contracts around the country and utilized by subs and GCs on the job to cooperatively resolve these issues to prevent or otherwise minimize the assessment of LDs. So we've got the tools. Let's use them on a proactive basis. And again, I wish you a Merry Christmas. And again, really encourage each of you to embrace the greatest gift being what you can't buy in a store, but it's your health and another day to enjoy life. Thank you.
Very well said, Tom. Thanks for your time today. We'd also like to thank our many national partners for generously supporting NUCA and our monthly webinar series. Today's webinar has been recorded. A recording of this webinar will be made available on the nuca.com website and on our YouTube channel over the next few days. And thank you for your time today to join us for this industry webinar and for supporting NUCA. Thank you for your time this afternoon, and please enjoy the rest of your week and the upcoming Christmas holiday.